Robert Katzmann is Chief Judge of the U.S. Court of Appeals for the Second Circuit, assuming that position on September 1st, 2013, so happy anniversary to you. At his appointment to the federal bench in 1999, he was Walsh Professor of Government, Professor of Law, and Professor of Public Policy at Georgetown University, a Fellow of the Governmental Studies Program of Brookings Institution, and President of the Governance Institute. A lawyer and political scientist by training, Judge Katzmann received his A.B. summa cum laude from Columbia College and a master's and Ph.D. in government from Harvard University, and if that weren't enough degrees for him already, he also decided to get a J.D. from Yale Law School, where he was an article and book review editor of the Yale Law Journal. After clerking on the U.S. Court of Appeals for the First Circuit, he joined the Brookings Institution, where he was a research associate, senior fellow, visiting fellow, and acting program director. His book includes the recently published Judging Statutes, which is for sale outside these doors, Regulatory Bureaucracy, Institutional Disability, Courts and Congress. He is the editor and project director of The Law Firm and the Public Good, co-editor of Managing Appeals in Federal Court, editor and contributing author of Daniel Patrick Moynihan, The Intellectual and Public Life, and editor and contributing author of Judges and Legislators. He has also been a public member of the Administrative Conference of the United States, a vice chair of the Committee on Government Organization and Separation of Powers of the ABA Section on Administrative Law and Regulatory Practice, and a board member of numerous organizations. Professor Emily Gold Waldman joined Pace University Law School faculty in 2006 after clerking for Judge Katzmann. At Pace, she serves as Associate Dean for Faculty Development and Strategic Planning and teaches constitutional law, civil procedure, law and education, and employment law. She is also the faculty director of the law school's Federal Judicial Honors Program, which places students in externships with federal judges in New York, Connecticut, and New Jersey. And with that, I'd like to invite Chief Judge Katzmann and Professor Gold Waldman to the stage to conduct tonight's conversation.
Thank you so much for that introduction, Julie. It's really a pleasure to be here with my former judge I served as law clerk for, and now a wonderful mentor to me. I want to jump right into the program. The title of tonight's discussion is Judging Statutes, Interpreting Congress's Laws Under the Constitution. And there's a lot packed into that title. Judge Katzmann has a view about how judges should interpret statutes, and that view is grounded in the Constitution. So tell us about that view and how it connects to the Constitution.
Before I answer that great question, I want to say how appreciative I am to be here this evening. I think that ConSource is an extraordinary organization and is essential in terms of educating the public, our students, hopefully lawyers and judges, as Jean was saying before. And so I'm honored that Julie would invite me to be here. And it's a real privilege to be here with Emily, who was a superb law clerk and has been an extraordinary teacher and scholar, and I'm so proud to share the stage with her. And it's wonderful also, I have to say just quickly, to see old friends like Maeva Marcus. We go way back, and it's always, well, we're still here. It's always great to see her, and Tori Whitman, who's old friend from NYU. And so this is very special to be here this evening. The question of interpreting statutes under the Constitution, let's look at the Constitution. And it's appropriate, especially that we do so, since Constitution Day and Citizenship Day are right around the corner. And when we look at the Constitution, what we see is that it is divided in certain ways. So Article 1 is the legislative branch. Article 2, the executive. Article 3 is the judicial. And I don't think that that's an accident, that the legislative branch, the lawmaking branch, is that first branch of government. And what the Constitution does is it sets forth in rather broad ways the powers of Congress in Article 1. It does talk about such things as qualifications for office. It talks about how the House of Representatives shall have a speaker. It talks about some requirements for lawmaking in the notion of presentment to the president of a bill that has passed Congress. It talks about the veto power. But what it doesn't really talk about is about the internal workings of Congress. It doesn't prescribe in any way how Congress is to go about doing its business. I think what the founders had in mind as we think about the Constitution and statutes, what the founders had in mind was the aspiration that there would be this congressional body that would be deliberative. When you look at the writings of Madison, he talks about deliberation. And he talks about how he hopes for a lawmaking system where the laws were not so numerous as to be unfathomable, or written in such a way that they're incoherent. So he had a sense that he wanted a legislative product that was sensible and could be interpreted. But how it was that Congress was supposed to work was not very much prescribed. There is the sense when you read some of the early writings of the founders, this view that there should be a Congress in which there was expertise that was developed as to issues. There's also a sense that that legislators would, related to that, would stay for a while, not forever. Of course, the notion of the House of Representatives of every 2 years, there would be changeover, but there was this sense of the development of institutional competence. But beyond that, as I say, the framers, it seems to me, almost deliberately decided that they weren't going to get too detailed as to how Congress was going to be organized or how it was going to work. And I think that goes back to what Gouverneur Morris said when he said that nothing human can be perfect. And we tried the best we could, leaving it to future generations to work out what we would call the kinks. And of course, they were thinking about constitutional government against the backdrop of the Articles of Confederation, of other efforts that hadn't worked as well. So I begin with this notion that the Constitution is largely silent about how the Congress is supposed to be organized internally, but is, it seems to me, quite of the view that it is up to Congress to decide how it's going to organize its processes. And I think that is something that's very important to keep in mind, that it is up to Congress to chart its own course as to what its lawmaking processes were supposed to be, with certain exceptions or reservations as the Constitution itself provides. And so we see historically that Congress does evolve as an institution in different ways. And over time, for instance, in the 19th century, you have the development of the committee system. Congress begins to do its work through committees. And you've got Woodrow Wilson in 1885, a young scholar, Woodrow Wilson, writing that Congress in session is Congress in exhibition, while Congress in committees is Congress at work. So that the committees would be basically the focus of the lawmaking process. The committees would be organized according to substantive areas of expertise or, of policy, foreign policy, a judiciary committee, you'd have appropriations committees, you'd have oversight committees. And these committees would be the committees which would be looked to in terms of developing bills, in pushing forward legislation. And so my first focus, in a way, in terms of the book and the way that I think of the lawmaking process as a judge, is really one of deference to Congress and its procedures. It's really an effort to try to figure out what it is that Congress had in mind, if it could be said to have a mind, and to give, to basically to implement and to be faithful to that view of the congressional work product.
And so that approach is often referred to as purposivism. And the leading counter approach is often referred to as textualism. So just to sort of set up the debate, tell us a little bit about textualism as a different approach.
So textualism, I mean, nowadays it's popular to say, we're all textualists. And to some extent that's, that's true. We begin with the text. The problem is, what do we do when the text is ambiguous? That's the issue. Not. I think all of us who are judges would say the text is what you start with, and hopefully it provides the guidance that you need, and your inquiry will be confined to the text. So textualists say that what we should be focusing on is really just the words in the document, the statute. There can be other aids that they will look at. They will look at dictionaries. So already they're going beyond the text. They use canons. So again, already they're going beyond the actual text. They're going to extra sources. Canons are certain precepts or guides or rules, depending on how you think about it, to guide interpretation. And what they don't look at, and this is, I think, the important point to be made in interpreting statutes, is they don't look at the surrounding materials that are part of the legislative process in the making of laws. So when I think about what judges should do, I think about that what a judge should do is to try to figure out what was Congress trying to do so that my interpretation of the statute is consistent with that. And so if I have a statute and the words are, for example, ambiguous, they're unclear, I don't know what Congress exactly had in mind because of the vagueness of the statutes, then I look to other sources accompanying the legislation, which I think are legitimate materials in understanding the meaning of that legislation. So I talked about earlier committees, Congress working through committees. So congressional committees will, a congressional committee from which a bill will emanate before it goes to the floor, will be accompanied by oftentimes a committee report. And the committee report will often give a sense of what the purpose, what the legislators had in mind. And the committee reports tend to be looked at fairly closely by the legislators in that committee. There is this view that staff people just put things in bills, in committee reports. The legislators don't know anything about it, and therefore no one should pay attention to it. That's sort of one of the textualist critiques. And while, undoubtedly sometimes that may happen, there are real constraints on that. And that is that when a legislator represents on a committee, represents to other legislators, not on the committee, what a bill is and what it's trying to do, and what the report is. If that legislator later learns that stuff has been put into that bill without his or her knowing about it, that staffer isn't going to have a very long career. And a scholar at Georgetown, Vicki Nurse, has written about her own experiences where she got to write a piece of legislation because the person who was had been charged with writing or drafting legislation and had tried to do something just like that. And I believe that her boss, then Senator Biden, said, you're out of here. So I think that these accompanying materials are very useful, because if you don't have those accompanying materials, then when you're interpreting a vague statute, you as a judge are basically going on your gut or your instinct without having a sense of what it is that the legislators had in mind. You're not honoring what they think is important. There's a lot that's been written recently, and empirical work that's been done by Abby Gluck and Laura Bressman, showing that a survey of legislative staffers, and what they say is that the most important thing to them in understanding legislation are the committee reports, the conference committee reports, which are the final reports. The House passes a bill, Senate passes a bill, different versions. They have to get together. They create something called a conference committee to iron out the differences. There's a report that's issued. Sometimes the report is actually the law that's enacted. And what they say is that's often far more helpful than these reports, than any other part beyond the text of the statute itself. If I could give you an example, a couple of examples that may make this clearer, and this is in the book. Congress passed a law saying that reasonable attorney's fees can be reimbursed as part of the costs in litigation involving handicapped education, where parents, let's say that their child is not receiving an appropriate education under the statute and files suit, and the parent prevails. And the question is whether expert consultants who are employed often by the lawyers involved in the case, if there are lawyers, sometimes there aren't, whether expert consulting costs could be included as part of the reasonable attorney's fees as part of the costs. Well, if you read literally the statute, you'd say reasonable attorney's fees has to be just lawyers. On the other hand, if you step back and say, well, what was Congress trying to do in this statute? And what they were trying to do was to make it easier for parents to bring these cases. And if you think of an expert witness as working with the lawyers and helping the lawyer make the case, then it becomes at least a question as to what is supposed to be included as part of the cost. And so that's a case where even something that seems unambiguous, when looked in terms of what it was that Congress is trying to do, looking at the purpose, it creates an ambiguity. And then what do? I look at the legislative history to see if it can be useful. And in that case, there was legislative history. There was a conference committee report where the Congress explicitly said that expert fees shall be included. I talk about it in the book, and Peter Strauss, who wrote one of the briefs in the case, has written extensively on this subject. And what it shows is when you ignore these legislative materials that are reliable, you run the risk of interpreting the law in a way that's counter to what Congress had in mind. And that's why I think, humility counsels that we judges need all the help we can get. Sometimes legislative history is helpful, sometimes it isn't. But where it is helpful, we should certainly look at it.
Are there times when you look at the legislative history and the history itself seems to point in two different directions, or does it usually lead you to one answer?
Sometimes the legislative history can be difficult to decipher, and that's a great question, because I don't want to give the sense that legislative history always gives you the answer. Sometimes it could leave you even more confused, and sometimes the legislative history doesn't really exist in any easily decipherable way. So if you look at the Affordable Care Act, for instance, which is a huge bill that was passed in untraditional ways, not through the traditional committee process as we know it, they're trying to discern what legislative history, what documents are useful, is a challenge, as Chief Justice Roberts wrote in his opinion. But what the court said was not so much a challenge was stepping back and thinking, well, what was it that Congress had in mind? What was it trying to do? And then from the Supreme Court's point of view, saying, we think we understand what the purpose was, and we were going to try to interpret the statute in a way that was consistent with that purpose. And so that's a case where the court was essentially agreeing with those who say legislative history can, at times, cannot be helpful. But at the same time, if you are a court, you feel that you have some responsibility when the case comes before you to give it your best shot in terms of interpreting the words of the statute.
So what do you think, if anything, could be done to make that process work more smoothly? So Congress passes the law, courts interpret it. It's really sort of an interbranch project. What could be done to make it work more smoothly so that it's easier for judges to make sure that they are interpreting the law in the way that Congress intended the law?
I think that's a great question. It goes to really lots of different issues, including how to restore greater deliberation to the process. And I think that Congress is under great strain in its own way. If you look, and I try to talk about this in the book, and this is sort of drawing upon political science literature. It's not original with me. Writings of Tom Mann and Norm Ornstein, who have this great, every couple of years, Michael Malvin, this sort of book that gives you these data on how Congress actually functions. And what you see is that, that now, if you compare recent years to 50 years ago, there are far more votes, even though people think, Congress now. They're critical of how Congress is voting. There are far more recorded votes now than there used to be. And so what that tends to suggest is that you have to vote on a lot more things, and it's harder to have the time to think about these things. And at the same time, Congress now is involved in the permanent campaign. You get elected, and you have to keep running for re-election from the first day that you're in office. And so that also takes time away from deliberation. And if you're in Congress, you tend to be there between Tuesday and Thursday, and you might come in on Monday night. And so it's a much shorter time frame, and all this, I think, makes things somewhat more difficult. I do think that there are certain things that might be considered. For instance, Professor Charnovitz at GW Law School has proposed this idea that when a bill is passed by Congress, that accompanying that bill should be some statement of what legislative history is useful. Now, this has been tried in the past with limited success, like the 1991 Civil Rights Act. But it's an interesting notion. Could the legislators actually agree that, or the leaders, this is what you should look at in terms of legislative sources? And I think that could be a useful, at least interesting thing to think about. Many years ago, I started a project with the late Frank Coffin, who was a great mentor and friend, a project called Statutory Housekeeping by Justice Ginsburg. And the idea is that when the courts issue decisions interpreting statutes, that those decisions would become available to congressional committees and relevant people in Congress. So where an opinion identifies a perceived glitch or an ambiguity or something that Congress might want to look at, make that fully available and accessible. And we do have that project right now. And in addition, the Administrative Conference of the United States is going to do something similar with agencies, where agency councils are going to go through court decisions interpreting their work, and where there is something like a glitch that's identified, they're going to send that over to congressional committees. So that's a way, at least for Congress, to have a better sense of the challenges that courts face, and that might, at least at the margins, improve the process.
Okay, one last question, and then we'll open it up. Just to bring it full circle, we've talked about how judges interpret statutes. What about when judges are interpreting the Constitution itself? As a judge, how is that different for you?
That's a great question. I think in some ways they are, they're quite similar in the sense that you're faced with words. I mean, what judges do, whether they're interpreting the Constitution or they're interpreting statutes, is they're trying to make sense of words. And oftentimes language is messy, and so the whole process is not a clean process. I think a difference, and so while I think there are similarities, I mean, if I'm looking at the Constitution, I would want to look at the constitutional history. I want to check my ConSource and make sure I've got the right interpretive documents. I would look at precedent. I would look at what's evolved over time in terms of the understanding of that constitutional section. And if I'm looking at statutes, I'm doing the same thing, except I'm looking at other kinds of evidence. I'm looking at the materials accompanying legislation. Now, a difference, however, is that usually when we're talking about statutes, we're talking about things that often go through changes and statutory evolution. And it's not meant to last for the ages in the same way, whereas when you're dealing with a constitution, you're dealing with words that have meaning that are supposed to really guide us for a very, very long time into the future. And that's why the amendment process is so difficult. So you have those words, and I think that that imposes even a higher obligation in terms of interpreting those words. It's hard. It can be harder, and so interpreting statutes can be in some ways easier than interpreting the Constitution, unless the precedents are very clear. The Supreme Court has spoken, and so on. But that's what we're not really we're not talking about that. We're talking about what happens when there's something that the founders could not have thought about, and we have an issue, and how do we interpret it to make it faithful to what the constitutional framers had in mind.
Great. So I'm going to turn it over to Julie.
To facilitate some audience Q&A, so we have microphones in both aisles. So if you have questions, just go ahead and line up behind either one. And I knew I could always count on Josh Blackman to have a question, particularly about statutory interpretation.
It'll be good, don't worry. So Judge, thank you very much. I will carry Justice Scalia's banner here for textualism. Justice Scalia often wrote that the Constitution says you vote on the text of the statute, you don't vote on a committee report. And another judge, Judge Patricia Waldman, said legislative history is like a crowd. You walk in, you see all of your friends saying, oh, I want that friend and that friend and that friend, right? How do you pick which legislative history you're going to rely on when there's a Republican saying this thing and a Democrat saying this thing and this sponsor saying this thing? As a judge, how do you pick and choose what you rely on to get that purpose?
That's a great question, and
It was not set up, I promise.
no. And let me say how valuable it is to have somebody willing to ask the first question. So thank you. We're all in your debt.
We paid him to be here,
Yeah.
so.
So I think that in response to the Scalia view, now let me say that, and I said this even before he passed away, that Justice Scalia has made a great contribution to our understanding of and thinking about the legislative process, and he pointed to some of the excesses of legislative history. What I'm saying is that legislative history is not the law, but it can help us understand what the law means and where the legislators themselves expect that legislative history, as part of their work product, should be read and thought about. Not to look at that legislative history is basically to show a disrespect for the legislative process, indeed an arrogance about understanding legislation. So, so that's the first point to be made. It's not the law, but it helps you understand what the law means. Let me give you just an example of why ignoring legislative history can be something you do at your peril. Let's look at the executive branch. Let's say that there is attached to a law in a committee report. Let's say it's energy legislation, and let's say that in the report says that within 30 days the Secretary of Energy shall do X. Now, do we really think that the Secretary of Energy is going to say, I'm not going to look at that report because it's not the law? Well, of course he's going to, or she's going to look at it, because not to do so is going to really earn the wrath of Congress, and that's not something you would want to do. So if you want to actually do what Congress would like you to do, you would look at that legislative history. And this is a bipartisan, nonpartisan institutional perspective. Perhaps the greatest defender of the use of legislative history today in the United States Senate is Charles Grassley. His views are very similar to that of Senator Leahy, who's the ranking member of Judiciary. And if you look at the hearings of Supreme Court justice nominees, you'll see Grassley asking every nominee what his view is, her view is of legislative history. So that's my answer to that first question. What was the second one again?
Patricia Wald, the judge, once wrote
picking
that
out your friends.
You go to a crowd, you see your friend there, you pick out this history, that history. How do you pick and choose without being so subjective, Judge?
Well, the way that that's a great question, and I think Harold Leventhal also.
She quoted Leventhal. That's
Leventhal,
exactly
right.
This is D.C. Circuit old school.
Right, exactly. So my answer to that is that when I think about legislative history that's reliable, I'm thinking about a relatively constrained set of sources. I look at the conference committee report, I look at the committee reports, and I look at the statements of the floor managers or the leadership at the time of passage. If you constrain yourself, limit yourself to those sources, you're not going to have the cocktail party problem in the same way that you would if what you said was, well, I'm going to look at everything. So if some legislator gets up on the floor who's not been involved in the legislation itself and gets up and says in the congressional record at the time that the bill is being debated before passage, this is what I think, this is what the bill means. Well, I'm not going to give that statement much weight because that person has not been involved in that process, that legislative process, is not part of the leadership. When the leadership says what a bill means, it's usually kind of a staged thing where they've actually come to some agreement as to what it means. If it's a conference committee report, that's the final deal. So that's my answer. You're never going to eliminate totally the abuses of legislative history, but the remedy is not its elimination. It's the more sensible use of reliable parts of legislative history.
Thank you, Judge.
Thank you. So we're going to be fair to both sides of the House, and we'll go over here for our next question.
Thank you very much, Julie. Judge, pleasure to have you here, and Professor. My name is Randy Milch. I'm one of the ConSource board members. I hope you forgive me in advance for leading you just a few degrees astray from your topic, because it occurred to me that the exercise of interpreting statutes in the modern era is interesting, but perhaps not nearly so important to most people as the interpretation of regulation. We, after all, probably live in a regulatory state, not really a state of, not a statutory state anymore. And so I wonder whether you think the same, how can you take the precepts that you have of a legislature to the situation of in the regulatory realm, where you have certainly what amounts to a legislative history of sort. We have the APA, we have notice and comment. Is that worthy of any sort of deference? Is that worthy of any sort of review as an idea about what is intended? Does it matter what was intended if you were now at a derivative state from this sort of hybridized aspect of the Congress having laws and the executive power and the president coming together in this administrative thing? So I was just interested in how you would deal with that set of interpretive issues.
It's an intriguing, very intriguing question. I'm not sure that I am fully in accord with your sense that we're no longer the statutory state, but the regulatory state, because statutes often have a regulatory component. to them. I mean, if you look at the Affordable Care Act, it's statutory, has a regulatory component. Look at the Civil Rights Act. Looked at the Clean Air Act, the Clean Water Act. They all emanate from a statute. The words emanate from a statute. The regulations are pursuant to that statute. And I think what you're really getting at is, and this could be the subject of another discussion, because I think you've raised a very interesting issue, is what are the doctrines or prisms by which we evaluate whether a regulation issued by an agency should be deferred to by a court. And that gets to the question of Chevron. That gets to the question of whether the court should assume a greater role in essentially second-guessing or putting its own independent assessment of whether a regulation should be deferred to. And I think that King v. Burwell, which I write about in the book, in the afterword, in the paperback, is sort of a nice segue to your point, because there, what the court is saying is that where the issue is so important economically, unless the legislation explicitly delegates regulatory interpretive authority to the agency, we, as a court, are not going to necessarily simply defer. And what will happen in future cases, I think, will really determine the vitality of Chevron as we know it. So I think it's a very good question, and I'll be interested to see.
It's your next book.
That's my next book. It would be good. Thank you.
Or our next Constitution Day talk. We have two gentlemen over here. Just say your name and where you're from.
My name is Martin Lockman. I'm a student at Columbia Law School. And Professor Strauss actually told me to come here, so that's the connection. But my question is related to statutory interpretation, but not necessarily to the textualist or purposivist viewpoints. There are occasions when, in interpreting a statute, you have the option to either kind of interpret the language narrowly or broadly. And in situations where a broad interpretation would end up preempting state legislation, is that something you ever consider, or is that something you think that judges should consider?
Whether judges should consider...
if there's existing legislation in an area, say a new technology has been invented and you have to interpret whether or not that falls under existing federal statutes, would you consider kind of the existence of state regulations that would be preempted by this decision when you were deciding how to interpret the statute?
To the extent that a federal interpretation would preempt a state scheme?
Yes.
I mean, that's certainly something that you consider in the mix. Well, everything depends on the context of a specific case, so I don't want to say something so broadly as to be meaningless and wrong. But, you know, when you're interpreting legislation that has implications for a state regulatory scheme, you know, that I think your antenna should go up that, gee, you know, you don't want to do any harm to the existing arrangements which, unless the legislation clearly calls for it. And I think that generally speaking, courts are loath to supersede what's going on in states unless there's been a strong congressional statement about that preemption.
Thank you.
Thank you. And we have time for one more question and one more questioner.
Hi, my name's Sean Doherty. I'm a political science undergrad at City College. So my question is, as far as statute complexity and ambiguity, to what extent should police officers be expected to understand their nuances?
I mean, that's a really good question, too. And there's a whole debate on that. And so I don't want to give you a simplistic answer. You know, there's this notion of, there's a doctrine of immunity. And the question is, what is it that somebody in a law enforcement situation should be expected to know? And it usually gets broken down to whether the right in question is one that is clearly established. And if the right is clearly established, then courts tend, in fewer circumstances, to give immunity. But if the right is not clearly established and it's uncertain, then law enforcement officers will often get a grant of immunity under that circumstance. But it's very fact dependent. I mean, you've asked a very good question, but it's very fact dependent, and I can't give you a crisp answer because it all depends on what the facts are. Why did you ask the question? Is this part of some research you're doing, or?
No, I mean, in one of my classes last semester, we talked about some cases that were about like traffic stop violations, for instance. There was I forget the name of the case, but there was a dispute over the signal lights on the car. That it was a very old statute, and it said it only mentioned one light, but now we have two, and there was so a person was stopped for having one of their lights out because the officer thought that you had to have both lights, but the statute itself was ambiguous because of that reason. And if I recall, I believe the court actually went in the officer's favor, saying that even though it was technically, from a textual standpoint, it wasn't a violation, the understanding of the state and the expectation was that you're supposed to have two lights. And so that's why it came to mind.
Very interesting.
Yeah, it sounds
Sounds
like
like a good class.
Yeah, it's a good class. That we have a person who's a part of the political science department at CCNY here, Professor Richard Bernstein, who does a lot of work with ConSource. So I just wanted to say hi, Richard. Wave hi. I know a lot of your students are here. Well, if we don't have any other questions, I want to thank Judge Katzmann and Professor Waldman again for being with us here tonight to celebrate Constitution Day and engage in, I think, a really interesting conversation. Judge Katzmann will be signing books out in the main hall immediately after this. I know I'm going to buy one and get it signed. As we mentioned, Constitution Day is actually on Saturday, September 17th. If you are on social media, follow us at ConSource. We will be tweeting the full text of the Constitution starting at 9 a.m. On Saturday. So if you're up at 9 a.m. on Saturday, haven't had the opportunity to read the Constitution before, this is a really fun way to do it in 140 characters. And so it's a lot of fun, and so I hope you will join us for that. And this video is going to be available online shortly after this, and so I hope all of you will go back and share what an interesting conversation this is with your colleagues. So join me again in thanking Judge Katzmann and Professor Waldman.